All attendees are in listen-only mode.
Good morning. This is Patrice Campbell. I'm chair of the Board of the Real Estate Appraisers. Today is March 3rd, 2022. It is 9 a.m. This is a public meeting of the Board of Real Estate Appraisers. We will now call this meeting to order. Let's begin by having Director Waters perform a roll call.
Tony Pastilli.
Here.
Vicki Sanders. Here. Chris Brownlee.
Here.
Chris Chippendale.
Here.
Patrice Campbell.
Here.
Larry Stark.
Here.
Christy McFarland. Here. Everyone's present and you have a quorum.
All right, the first agenda item is our hearing matters, and which I'm going to be recusing myself. This is Patrice Campbell. I'll recuse myself for the hearing matters.
So I believe the Vice Chair, Tony Pastilli, will be taking over.
Board members, my name is Tony Pastilli. I'm Vice Chair of the Board. All the members are present. The next matter on our agenda is case number APR 2020-02, the matter of Colorado Board of Real Estate Appraisers v. Anthony Michael Vigil. In this case, the board will consider an initial discussion issued by the Administrative Law Judge, Office of Administrative Courts, finding violations of the applicable statute and rules and recommending discipline. The respondent filed exceptions to the initial decision, and the parties have provided briefing to the board. Y'all have noticed that we have many attachments in this individual case. The issue today before us is whether to affirm, modify, or reverse the initial decision issued by the Administrative Law Judge. We have representatives from the Attorney General's office. I believe Heather Whitman is here with us today, representing us in this matter. Also present, Eric Turner, Deputy Director, as well as other members, obviously, of the board and staff. We'll make a motion if someone is willing to enter into executive session to discuss. We will resolve any procedural matters and ask any questions related to the process during executive session. May I have a motion to enter executive session?
So moved.
We have a motion. Do we have a second?
Second.
Motion and a second. Any discussion?
Aye.
All in favor say aye.
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 We have a unanimous decision. We'll now adjourn the public meeting and go into executive session.
Tony, before you, just as a matter of procedure, you only need to go into executive session if you have questions you need to ask me as adjudicatory counsel for the board. So it's not a requirement, but if you have questions, you certainly can.
Thank you, Ms. Whitman. My understanding from our conversation yesterday is that it was necessary to answer two questions that we wanted to adjourn to executive session. If there's a change in that, we certainly can do that here at the public meeting. We've already voted, though, to adjourn to executive session. I don't know procedurally how we would reverse that if that's the board's pleasure.
Heather, you're on mute.
It's your option, and it sounds like you do want to go into executive session, which is fine. Just for the record, if you would add that we're going into executive session pursuant to CRS 246402-3A2 for the purpose of receiving legal advice.
Is that acceptable to the board members to be included into the motion in the second? And the vote?
Yes.
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 All right. Then let's adjourn to executive session.
All right,
So-
thank you.
Yeah, so board members, if you would please turn your cameras and microphone off and then go into the other platform.
Very good. My name is Tony Pasilli. I'm the vice chair of the Colorado board. The time is now 9:30 Mountain Time, and the board is back from its break to resume the discussion from executive session. We'll return to the open meeting discussion. Before us is a decision to grant or deny oral arguments by the respondent or by the state in this matter. May I have a motion from a board member to grant or deny the request?
This is Mickey Sanders in the case 2020-0002. I move that we deny request to grant oral arguments.
Thank you, Member Sanders. Is there a second to that motion?
Second?
We have a motion and a second by Member McFarland. Is there any discussion? Hearing none. Board members, please vote by saying yes if you approve.
Yes.
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 Those opposed say no. Motion passes. Next item on our agenda is to accept, deny, or modify the decisions, recommendations by the state for a $7,000 fine with 15% surcharge, which equals $8,050. That would be item one. Item two is the completion of coursework as specified in the initial decision. Again, we have the opportunity to accept, deny, or modify these recommendations. Before asking for a motion, is there any discussion on the recommendation?
Mr. Vice Chair,
I'd like to talk about, oh, go ahead, Mickey.
No, Christy, you go ahead, please.
Well, I'd like to talk about considering, in lieu of the fine or a portion of the fine, instead public censure. I'd like to hear from the other board members on this.
I agree with your recommendation, but also to include the education classes to some degree that the ALJ recommended.
Board members, I'd be in favor of just accepting the initial recommendation and adding public censure. Keep in mind that there's 4 appraisals associated with this complaint, one from 2016, one from 2017, one from 2018, one from 2019, and there was an initial non-disclosure of 2012 where the respondent didn't acknowledge prior disciplinary action in another state.
Tony, I agree. We keep the fines as recommended in place and have a public admonishment or censure.
I want the board to be comfortable with the final, conversation here before we make a motion. Is there anyone else that would have anything to add or comment on? Can we get a motion to accept, deny, or modify the initial recommendation from the administrative law judge?
So what I'd recommend here for you, Tony, is that my understanding is that it seems like you're interested in modifying the sanctions. And so what I would recommend is a board a motion where you accept the findings of fact and law of the administrative law judge, and then you can make another motion to modify the decision with regard to any sanctions, as it sounds like you're considering maybe modifying what the ALJ recommended in the initial decision. Does that make sense?
Absolutely. I assume that by accepting the final determination, we would accept the final agency order as well, but if it should be separated, we can certainly do that.
Just so we're clear about what's being modified, I think the motion, as I heard it, seems to muddle everything together. So what I would recommend is that you that somebody make a motion to accept the findings of fact and the conclusions of law, and then vote on that, and then I would then modify the sanctions. It sounds like that's what you want to do, and that's certainly within your rights to do that. Does that make sense?
It makes sense. Thank you, Ms. Whitman.
Okay,
I would like to make the motion then to accept the findings of fact that are presented to us by the administrative law judge. Is there a second?
Second?
Any discussion? All members in favor say aye.
Meeting minutes
Aye.
from January 6, 2020.
Motion passes.
Could I have a
Next
motion
item would be
to
to
approve
accept
those
the
minutes?
recommendation for
I move that we
disciplinary
approve
actions
the meeting minutes
as outlined.
from January 6th.
Again, it's $7,000 fine, 15% surcharge, and
Okay, thank you. We have a first and second.
Now
Now let's
let's
take a
And
vote.
Tony,
All
just
those
to jump in
favor,
one more
say
time,
aye.
the conclusions
Aye.
of law would
Aye.
also need to be accepted.
Opposed?
Sorry to keep interrupting. And then yes, then
All right.
as far as the
That
deliberation
has
on
passed.
the sanctions and what you all ultimately want to do in this case.
Next, we will go into
I'm sorry, can you say that again, Ms. Whitman?
Yeah, so a motion accepting the
Policy
conclusions
matters.
of law, and then the deliberation on the deliberation on the sanctions.
Do we just make a motion in a second and have a vote on to accept the
Yes.
finding of fact?
Yes. And then the conclusions of law. I didn't hear the actual language. Were the conclusions of law included in that?
If they weren't, I'd like to amend my initial motion to include that. Is the
Second.
seconder okay? Seconder is okay. Any board member disagree with including, as Ms. Whitman suggested, the additional language to that motion and second? Hearing none, can we amend that motion, Ms. Whitman?
Yes.
Okay. On to the second question. Does the board accept, deny, or modify the recommendations presented by the ALJ? This is in relation to the fine and the education. Open for discussion. We've had some discussion. Is there a motion? Anyone want to make the first motion? Something to get on the table that we can then discuss or modify?
Tony, this is Larry. I'll make the motion that we follow the administrative law judge's recommendation, and is at this point that we should also recommend the amendment to that would have public censorship.
Thank you, Member Stark. Is there a second to that motion?
Second, Sanders, second.
And Tony, to be clear, I had a question in that. It wasn't completely the motion. Is this the place that we then recommend the censorship?
Yes.
All right, so my motion
Yes.
is that we accept the ALJ's recommendation and we modify it to include public censorship.
Thank you, Larry. Is that in the form of a motion? Would you like that to be a motion? Member Sanders, would you accept that as a second?
Second.
Any discussion on the motion and the second before us? Hearing none, all in favor say aye.
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 Opposed? Motion passes. Anything else, Ms. Whitman, that we need to consider as a part of this public hearing?
Yes, Vice Chair, I would recommend that you invite a motion to direct adjudicatory counsel from the Attorney General's office to draft a final agency order reflecting the board's determinations.
So moved. Is there a second?
Second?
A motion and a second. Any discussion? All in favor say aye.
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 Opposed? Motion passes.
And then one more, and that would be to delegate authority to Eric Turner to sign any order that you all ultimately issue in this case.
Again, so moved.
Second?
We have a second from Member McFarland. Any discussion? All in favor say aye.
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 Aye. Opposed? Motion passes. Thank you again, Ms. Whitman.
Thank you very much.
That was a part of your guidance to me, and I didn't have the last page in front of me. I apologize.
No problem. Good job. So it's very nice working with you all. Do you need anything else from me?
I don't believe so, ma'am.
All right. Thanks so much. Have a good
Thank
day.
Thank you.
And I've let Patrice know to come back to the meeting, Mr. Vice Chair.
Thank you.
So, the next item on the agenda would be to call a motion to approve the minutes. Do I need to take another roll call? Or do we need to take another roll call, Marcia?
Actually, Madam Chair, we're going to move into the rulemaking hearing, so yeah, we should do another roll call, and
Okay.
then you've got the script for the rulemaking. So,
Okay, all right.
starting the roll call, Tony Pasilli,
Here.
Larry Stark,
Here.
Christy McFarland,
Here.
Chris Chippendale,
Here.
Vicki Sanders,
Here.
Patrice Campbell,
Here.
Chris Brownlee.
Here.
They're all present. You have a quorum.
Okay, thank you. Today is Thursday, March 3rd, 2022. It is now 9:45 a.m. This is a permanent rulemaking hearing pursuant to the Administrative Procedure Act found at Section 24-4-103 of the Colorado Revised Statute. To hear oral testimony and accept written submissions related to proposed amendments concerning the rules governing the practice of real estate appraisers referenced in the Code of Colorado Regulations as 4 CCR 725-2. Sections 12-10604-1A I of the Colorado Revised Statute authorizes the board to promulgate and amend these rules. This permanent rulemaking hearing is being conducted pursuant to the process as set forth in the Administrative Procedure Act. During this hearing, the board will hear testimony and accept written submissions regarding Rules 5.1 with respect to the appraisal experience gained under the guidance of another credentialed appraiser. In addition to my fellow board members, here with me today are Director Waters, Deputy Director Turner, and Senior Advisor Lutz from the Division of Real Estate, and Chris Aguilar from the Attorney General's Office. The public record will consist of all testimony and all written information submitted within the allowable timeframe. In addition to the public comments today, the board will review any written materials to make the final decision on the proposed amendment. The public record will close at the end of this hearing. Now let's have Director Waters explain the proposed amendment to Rule 5.1.
So board members, we're proposing that you revise this rule just to clarify that if an appraiser is gaining experience under the guidance of another appraiser, that the appraiser providing the guidance be appropriately credentialed for the work that's being done and also be in good standing. And to give you some background, Eric and I have both been kind of dealing with the appraiser application since last fall. An example of what we've seen is we've had an applicant submit an application to upgrade to like a certified general credential, but they have indicated that the person that provided them guidance was also a licensed appraiser, and a licensed appraiser on their own cannot perform that type of work. So this rule is just to make it very clear for the community that you've got to have the appropriate level of license to be providing that guidance, and then also be in good standing, which means not having any disciplinary actions in the prior 3 years.
Thank you, Director Waters. At this time, we will start with the testimony phase of the rulemaking hearing. Each speaker will have 3 minutes to speak. Please speak clearly and slowly for the recording. Please state your full name and identify the name of the organization that you are representing, if applicable. Finally, please limit your testimony to only the proposed amendments and do not duplicate testimony. If the board or any of its representatives have a question regarding your testimony, we will ask you when you have finished your testimony. If you desire to provide testimony, please raise your virtual hand so division staff know who to call on.
Thank you, Madam Chair. If anybody from the public who would like to speak on this rule, please, there's an icon that looks like a hand. If you click that, we will call on you. And Madam Chair, it looks like we have Mr. David Clayton. David, you may hit your microphone and unmute yourself. And it looks like he changed his mind. And I see no one else that would like to address the board, Madam Chair.
Okay, so
I'm sorry, we got a last minute hand up, and that's a Joanne Apostle. Joanne, you may unmute your microphone. You are unmuted, Joanne. Unfortunately, I think there's some technical issues. All right, I don't believe we'll be able to listen to Joanne Apostle.
I did just Joanne, I just sent you, if you're going to call in via phone, I just sent you the PIN information, so.
should we give a couple more minutes then?
Why don't we give her just a few minutes to see if Joanne's able to join us. It looks like you're unmuted, Joanne. You should be able to, can you?
Yeah, unfortunately, we just don't have any audio.
Okay, should I move on?
Yes.
Okay. So hearing no testimony, we will now consider the proposed amendments to Rule 5.1. Do I have a motion concerning the adoption of the proposed amendments?
So, Madam Chair, I think we're going to try one more alternative so that you can get the testimony that Ms. Apostle signed up to provide. Natalie's going to try making her a panelist.
Okay.
Joanne, it looks like I'm unable to make you a panelist because it's showing that you're offline. I'm wondering if you're having internet connectivity issues.
Madam Chair, can we make an amendment to the agenda to allow the technical difficulties to be resolved? Rather than, I would feel uncomfortable not allowing the public to have opportunity to comment.
That's another question I was going to pose to your AG as well, is if we could just move any adoption to the end of your agenda. And that way, if she can get her technical issues figured out, you can hear from her directly, or she is more than welcome to email what she wanted to say to one of us, and we can read it to you so that you can consider her comment.
Okay, so let's move this rulemaking to the end of the agenda. And we can just go forward.
That's my suggestion.
Okay. All right, so let's go to the next agenda item, meeting minutes from January 6, 2020. Could I have a motion to approve those minutes?
I move that we approve the meeting minutes from January 6th.
Second by Tony Pistone.
Okay, thank you. We have a first and second. Now let's take a vote. All those in favor, say aye. Aye.
Aye.
Those opposed? All right, that has passed. Next, we will go into policy matters.
Madam Chair, item A is a continuation from Board Member Pastilli from last meeting. I didn't know if you had anything additional to discuss.
No, Director Waters, I spoke with Chris Egler in the interim, and I have nothing else unless the board wishes to continue the conversation. I do not.
Okay. Legislative update.
So, board members, your sunset review was presented to our committee of reference last week, I believe. Time is relative these days, but they did vote to move it on to be in bill format. So it will be heard in committee on March 16th. They moved it forward with all of the recommendations that were in the sunset review. So I'm just giving you an update about that. And then also, you had 4 board members confirmed on Monday by the Senate, and their confirmation will go on the Senate as a whole as well. So those are the legislative updates applicable to you.
All right. And then are there any agenda items that we want to add for the next BOREA meeting? Okay, hearing none. Now we have the citizen participation period. Any person may bring their concerns about matters on the agenda before the board. Speakers are requested to limit their remarks to 2 minutes unless allowed additional time by the board. Are there any public members who would like to speak?
Yeah, once again, public members, there's an icon that looks like a hand. If you click that, we will call on you and unmute you. And it looks like we have a Ms. Gasalova. You have been unmuted.
Good morning, board. Can you hear me?
Yes.
Yes.
Okay. I am here as just the general public and just make sure that your system works. I was going to observe your session because I went through the appraisal process and it was nothing than the bumpy struggle. One question for those 2 minutes I'm allowed to speak, I would have, is something like rural fees that are charged on the appraisal report regulated somehow, or would that be something what should be regulated? So as a consumer, we know if we are paying appropriately for the services and what defines this kind of the rural fees. That's my question and comment all in one, and thank you for your work.
Director Waters, do you want to speak to that, or?
So appraisal fees themselves are not regulated. It's basically negotiable between the appraiser and the client. That's pretty much all I can speak to about that. If they were going to look at regulating appraisal fees, I think that is something that you would have to address with the legislature. I don't think our individual boards and commissions have the authority to regulate professional fees for their services.
And Madam Chair, I do not see anybody else.
Okay, thank you. Now we will move into the complaint investigations. This complaint is 2020-2006. James Fuller was the investigator.
So, Madam Chair, we'll actually take complaint matters A and B together because they were co-respondents. So complaint matter A is 2020-2006. Complaint matter B is 2020-2021. This was a commercial property located in Cherry Creek. There were multiple allegations filed against both respondents. The lead appraiser was complaint matter A. The secondary appraiser was complaint matter B. And basically, he reviewed the work of the first appraiser and just checked the math based on what they told us. There was a full investigation completed into this complaint, and we didn't have any evidence to substantiate the allegations filed by the complainant. The matter was closed at the staff level. However, the complainant disagreed with the outcome of the board's investigations, and that's why we have presented it to you today.
Thank you. And so does anyone have any comments about the original investigation or the current complaints of the decision made at that time?
So, Therese, this is Larry. I did a review of all the documents that the state provided us, and though I think that many parts of the appraisal were well prepared and didn't really see use path issues per se with regard to the report. What I did see was, I think, probably a differential in a matter of opinion. And I think that, again, many pieces of this report were well done. I think that in practicality, if this were being valued, this was like a 27,000 square foot site, so it's about a half an acre. It's located on University near 3rd. It is a part of a larger development, but the task assigned to the appraiser was, as the appraiser stated, to value the site as is vacant and available for sale or lease, not subject to the existing improvements. I think they correctly concluded that they shouldn't consider an assemblage, because you don't know whether you would be able to assemble this site or not. It is in fact assembled, but that doesn't mean that under the hypothetical that the appraisers were required to value it in, that it would in fact be granted this assemblage. It may be that the properties next door wouldn't allow that. So with all that said, I agree with what we have is really a pad site. If you're assuming this is vacant, you've got a 27,000 square foot pad site. The appraiser did some fairly extensive analysis and basically came to the conclusion that somewhere between 9,500 and 12,000 square feet of buildable area would be placed on it, probably on the lower end of that because of parking requirements. The site is severely restricted by the neighborhood association that's to the west, so you can't have windows on the rear and perhaps on the side of the building. Really pretty much precludes restaurants because of ventilation systems. So there are a number of restrictions, but on the other hand, this is really a pad site. I mean, if you think about a Starbucks, for example, and I'm not suggesting a Starbucks would be allowed on this site, but a Starbucks drive-through is 3,500 square feet. So you would have a great deal of parking associated with this because you'd have 3,500 square feet of building area and, you know, the balance of 23,000 square feet of land area for dry parking landscape. I could see this being a bank pad, family foundation pad. I mean, it's in an incredibly good location with a great deal of traffic, though it is one-way traffic on University. So in this situation, it goes to two-way just past the site. So there are a number of limitations, but the valuation of this at somewhere around $250,000, which is, I don't know, $3 and something per square foot, I think intuitively is a low value. So going through the report, kind of believe that an appraiser doing this would have done some test of reasonableness. For example, without getting into too much detail, if you did have a 9,000 or 10,000 square foot building built on this site in Cherry Creek as of 2019, it would have probably leased for $30 to $40 a square foot. And if you took $30 to $40 a square foot and you applied that to 10,000 square feet and you used a cap rate of maybe 5%, you would have had a value of somewhere between $600 and $700 a square foot for the improvements. And then let's say that 15% of that, or maybe 12% of that, or 17% of that would be allocated to land. So kind of a land residual technique. You'd come up with a value of somewhere between $900,000 and $1.1 million. So that would be one way of looking at it, and the appraisers chose not to do that. They looked at comp data, and I think appropriately used comp data on a price per buildable square foot basis, but it concluded at the extreme lower end of the range of all the comps. And personally, I feel like that was inappropriate. This could be a judgment perspective, but I think to back away and look at the bigger picture, this is a pad site. This is the size of a site that Quick Lube would be on, or that a Starbucks would be on, or that a family office would be on, or that a dental office would be on. Again, restrictions because you've got window restrictions and you've got some other restrictions imposed by the adjacent property owners. But pads are typically selling from $750,000 to $1,250,000. So though in the world of appraisal, you're looking at whole numbers, 255,000, I think, that was concluded versus, let's say, 750,000 to a million. One could say that the value, again, I'm not valuing the site. I'm just kind of looking at what's reasonable, and it's just kind of in my wheelhouse. It's on the extreme. It's beyond the extreme lower end of value. So I didn't find fault with the report. I found issue with the final conclusion analytics. And again, it was beyond the scope of what we're allowed to do to go out and gather other data or to do any alternative analysis. But I would suggest that the value was based on information provided below the range of reasonableness. And again, the balance of the report I didn't really have issue with. It was just the way that the appraiser concluded value.
Thanks for that, Mr. Stark. I'm not sure where we go forward with this. Again, I agree that I don't see that there were issues with the actual complaint as far as some of the items they brought up.
Well, Patrice, the complaint, I agree. Many of the items that were brought up by the complainant, in my view, were probably partly out of lack of knowledge for exactly how the appraisal process works. But their bigger complaint was just that the value was wrong. And again, I'm not valuing the site, but I'm telling the board that I'm personally very familiar with this area. I work in the area frequently. And then more broadly, just a pad site on Colorado Boulevard. Again, two-way traffic, doesn't have the restrictions, et cetera. We're selling for dramatically higher prices per square foot, per buildable square foot, or just in total dollars. So I understand the complainant's concern that this value is just so low that it really didn't make sense. So, I don't know what the value is, but my opinion is the value was missed. And that was one of the complainant's issues. And I understand that the investigator didn't agree with the complainant in that area either. And I don't know where to go. I'm just giving you my perspective.
Madam Chair, I'm a residential appraiser, so I appreciate Larry's comments. I don't fully understand the commercial appraisal methodologies, but within USPAP, if you follow the appropriate methodologies, you'll end up with a credible report. And Larry indicated that you really don't agree with the final conclusion. Were there flaws in the way that the appraisal was constructed that led to a unreliable or non-credible value?
Well, Tony, as I mentioned, I think that one would do a test of reasonableness if you're and one of those tests of reasonableness is looking at the site as a pad site, because that's what it is. It's 27,000 square foot. It's mid-block. It's in the middle of what is an existing building. But again, the instruction was to look at it, and the appraiser appropriately did that as a standalone parcel of land. But one test of reasonableness would be what a pad site sell for. And there are many pad sites that have sold within a few mile radius. And again, then you make your appropriate adjustments. And I didn't go through that process beyond what we're to do in all of this. But I just know intuitively that unless there's something I missed when I went through the review of the appraisal, the appraiser's response, the investigator's comments, this site would have sold for more than $255,000 if it were available and everything else under the hypothetical were in place as of 2019 based on other market data. So I think that, in my view, the appraiser kind of missed the fact that that maybe there's a different data set though they did a great job of analytics of the data that they gathered, then they concluded at the extreme low end of the range with comps that were really outside of the Cherry Creek boundaries and that weren't really walkable to Cherry Creek. This site's completely walkable into Cherry Creek, surrounded by a lot of high-end projects. I could just see some form of commercial development put on this 27,000 square foot site that would render, you could have a Verizon wireless store. They pay $35, $40 a square foot. You do a land residual technique, and that would bring you back to 750 to $1 million. So again, I think the test of reasonableness that one would do would bring you back around to consider that perhaps your valuation at the lower end of the comp range is out of order. Again, my opinion, and so these become one appraiser's opinion versus another. So to specifically answer your question, Tony, I think that if the appraiser missed anything, it was by looking perhaps at a test of reasonableness for a land residual technique, or looking at this as a pad site and what a pad site sold for. So, and then there's a theoretical perspective, not to get into too much detail here, but when you're looking at a property on a price per buildable foot, as the site gets smaller, the value per buildable foot generally increases, and it really wasn't realized here. Most of the comps were much larger because that's what the comps were. They had a much higher density because they would allow 6, 7, 8 story development. So the appraiser had no choice except to use that data set. I think perhaps there was an adjustment that was missed. And then my final comment would be, if you can imagine on University Boulevard, again, limitation, this is the one-way section of University Boulevard. You have a 27,000 square foot site. You could build a 8,000 or 9,000 square foot freestanding building. It is literally adjacent and walking to the Cherry Creek shopping district and restaurant area. And you would have a great deal of surface parking, which doesn't exist in the Cherry Creek market. So there are a number of desirable things associated with this site that would have suggested a higher price per square foot for the land, in my opinion.
Madam Chair, thank you, Larry. I respect your opinion, and that's why I asked. We have two investigations that have reviewed the appraisal and haven't found conclusion that the appraiser did anything contrary to use pad. And again, I'm a residential appraiser. I don't understand the commercial techniques. I would be inclined to recuse myself because of that. I respect your opinion, Larry, as an appraiser and a board member. But I'm conflicted because we have an investigation, 2 of them, that suggests no wrongdoing in the reports. I do have one other question. Is the complainant actually an intended user? And can anyone open a complaint, or does it have to be someone that's associated with the report itself?
So I looked at the intended user section, and the complainant or any relative didn't appear, but I don't understand the exact ownership structure to be an intended user by the appraiser. But I mean, Patrice or Marcia, maybe you can expound on this, but I don't think it has to be an intended user that turns a report into the state for investigation.
That's correct. Go ahead, Marcia.
Board members, anybody can file a complaint with us.
Can anyone receive anyone's appraisal?
Pardon?
Can anyone receive anyone's appraisal and rely on it if it wasn't included in the intended use or intended users?
Well, I think that's something that you have to factor in when you're looking at these complaints. Because if you have somebody who is not associated with a transaction that gets a copy of the appraisal report and doesn't understand it, but the client understands it, I think that's something that you need to kind of factor in when you're evaluating it. I just also wanted to remind you all, your authority is whether they comply with the uniform standards of professional appraisal practice or not. we get a lot of value complaints, and the board does not have jurisdiction over values. So one of the things that the staff has to evaluate when they go through and do a complaint investigation is whether we have evidence to substantiate a violation of use path, regardless of what the value conclusion is.
Okay, so Marcy, if they missed an approach to value, or if they missed a test of reasonableness that would have led them to question the analytics they've done, because in the report itself, it's a matter of opinion. They concluded, based on data and had their opinion that was presented. In my view, the appraiser missed kind of a test of reasonableness in looking at other data and other analytical tools available to the appraisal community. And in so doing that, they likely missed properly valuing the asset. Is that a use path violation?
Well, that would be my question to the board. The test of reasonableness, what part of use path does that fall under?
Well, the appropriate methodologies, to produce a credible assignment result, but also to bring up what Larry's referring to, I think, is would our peers do something similar in a similar situation? And I'm hearing Larry say that he would. Again, this is all I'm gonna say because I don't know enough about this process because it's commercial appraisal. I've read everything, I just can't make heads. I'm not.
Board members, if I may, Mr. Vice Chair, I do believe it would be helpful to do a short executive session to provide some legal guidance in connection with these two complaints. If, again, it's up to the board, that's a suggestion from me.
That sounds like a good idea.
I would agree to that. And can we just dial back into the same number that we dialed into before, if we dialed in?
Yes, you can use that same one.
Perfect.
So you're going to need to make a motion and then a vote.
Okay, I make a motion to move to executive session.
I'll second that.
Ms. Chair, if you could please use the citation to the appropriate statute.
Okay.
In case number 2020-2006 and as well case 2020-2021, I move that we go into executive session.
If you could please, this item's chair or somebody else refer to the appropriate statute on this for the record.
Is CRS 24-64023A2? Is that correct? Based on that Colorado's revised statute, we would like to make a motion to go into executive session. Do I have a motion on that again, please?
Motion.
I would make the motion that we move to executive session.
Okay. A second, please.
Second.
All those in favor, say aye.
Aye.
Aye. All those opposed? Okay, we will shut our cameras down and move to executive session.
And remember to turn off your microphones as well for this meeting.
Okay. Thank you. So, we're on complaint 2020-2006 and complaint 2020-2021. Do we want to have any more comments on this before we make the motion?
Hey, Patrice, I have a couple of other comments. First, I want to make a correction to a comment I made earlier. The value that was placed on this on a per square foot basis was between $9 and $10 a square foot. And I think I said 3 or something. I'm not sure where I came up with that. But anyway, after really having a chance to kind of form my thoughts, I think this is in my view, a difference of opinion, and that's not a use path issue. It is that I have a difference of opinion with the appraisers that did the analytics. And appraisers, if you work in the field, we frequently have difference of opinions. I don't find a specific use PAP issue, just a different perspective. So, that would be kind of my conclusion. We have an investigative report that found ostensibly no issues with the report. As I mentioned, I thought the report was well written, very articulate. I would have approached it a different way, but many people in our profession approach things in different manners. So my perspective is that we accept the past investigative report and Marcy's agreement with that, I believe, and that we then move on.
So is that a motion? Are you making a motion?
I can certainly make it as a motion that agree with the investigative complaint and conclusions, and that we don't see any other use PAP violations. That would be the motion.
Do we have a second? I'll second that motion. This is Patrice. Now let's all take a vote. All those in favor of accepting the staff's recommendation on complaint. No, sorry. No.
2020-2006 and 2020-2021. Did we, as part of the discussion on this motion, did we talk about directing the staff to write a letter of concern on behalf of the board?
No. Do you want to make that amended motion?
And Board Member McFarland, we had previously issued a letter of concern.
Okay.
But you wanted me to follow up, I believe, with some additional information.
Yes, I think that would be helpful and put fellow board members' concerns. They could be included in that letter and yet still uphold the investigative conclusions. So I would amend the motion to include a letter of concern that will be sent by the staff to the respondent.
Second that. Second that. This is Patrice. Now we'll take a vote. All those in favor of accepting the original recommendation, say aye.
Aye.
Aye. All those opposed?
Madam Chair, I'd like to have the record reflect that I abstained from voting.
Okay. Thank you. Okay, now we will move on to complaint number 2021-1630.
So the investigator for this complaint is Scott Wentz. With this complaint, the respondent certified that he performed a complete visual inspection of the interior and exterior areas of the subject property. The investigation revealed that the respondent had not inspected the subject property. He did not report any professional assistance being provided for this report. The respondent did not have data and stated no methodology for the supplement sales comparison approach. The income approach to value has been completed. Potential violations are 12-10-6131B, violation of Part 6, 12-10-6131G, failure to comply with use PAP, Board Rule 12.8, which is having the full license or permit number or the appropriate abbreviation, the record keeping rule, and standards rules 1 and 2. The recommendation for this is dismissal with subsequent ed in residential report writing and case studies. That's 15 hours plus the exam. 7 hours or more in comparative analysis and or supporting adjustments, and the BOREA work file course. And Scott is here to answer any questions that you may have.
Scott, how many total hours is that of recommended coursework?
It would be about 23.
I'm sorry?
23.
Thank you.
I have a question. I think the biggest thing here was that they didn't inspect the property, but also some other things that kind of cropped up were under the site. It says the respondent was asked if he knew the subject property, and he said something that I understand what he was talking about, but was there no legal or assessment information that he could have relied on for this?
He should have had legal or assessment information that he could have relied on. Correct. That is correct. Yes, it was.
Okay. Well, that seems sort of strange to me. You'd go somewhere for the information.
So Scott, remind me, is this the case, so I don't have to look back in the file, where one of this person's assistants did the inspection and they were on the phone while the inspection was going on, but they weren't present?
That is correct. That is correct, sir.
Okay, thank you. Marcy, could you tell me again the courses that are suggested?
So the recommendation is for the residential report writing and case studies, 7 hours or more of comparative analysis and supporting adjustments, and then your work file course.
Does that make this person understand that they need to be there at an inspection, or are we?
They will get a copy of your report. Unfortunately, there's certain areas that we don't have education that deals specifically with the issue, and like showing up for the inspection is one of them.
Is a fine appropriate or possible? I mean, because a lot of issues, obviously, but that seems to be a little, to your point, we're not really addressing that was a pretty big issue. And I don't know, fine is the right answer. If we don't have education, are there other tools at our disposal?
Well, Chris, my perspective with this is that it's easier to pay a fine than it is to spend 23 hours of your time taking classes, and you have to pay for those classes, of course. I'm with Patrice. My biggest issue here is that, you can do an appraisal without inspecting the property at all. You just have to say, I didn't inspect the property. And in this case, he had somebody else that inspected it. I understand the mitigating circumstances that you mentioned. Bigger issue is that the report was incorrect. He said he inspected it, and he didn't. He had somebody else that was doing it for him. So, I don't know how we address that specifically, but I'm sure it's a pretty simple concept. I'm sure the appraiser now understands that if I don't inspect it, I need to say who did. So
I was just suggesting maybe in addition to everything else, not in lieu. So.
Right. Yeah. No, I understand that. So my perspective is that 23 hours of coursework is fairly substantive, and it seems like it covers everything. So I'd make a motion to agree with Scott's recommendations, unless others have any questions.
Scott, on this report also, he didn't mention the assistance from the other person, right? In your opinion, was it kind of just an overlook there, or since he didn't go on the inspection, was it something else?
I believe just from communicating back and forth with the respondent, just with his story with his wife in the hospital and so forth, I believe that it was probably an oversight on his part for not including that into the actual report. But My other thinking too is since it actually was, I believe it was an FHA report, and the actual person that actually did the actual inspection was not on the FHA roster. I don't know if the actual respondent was trying to be misleading or not, to be honest with you. He did have some good explanations as far as why he wasn't there, and as far as as far as being on the telephone with the appraiser the whole time through the inspection. Myself, I've never done that. Being a fee appraiser, I've never utilized any source of resource like that before in the past. So I'm not real certain as far as if it was omitted by mistake or if it was purposely omitted. I'm sorry.
Yeah, we can't know that. But if this happened on this one, it's possible it happened again. So it's good to address it, I think, and make them understand that is. Say what you did, and if you didn't inspect it, and then obviously it wouldn't have, fallen under the FHA guidelines. So,
correct.
I agree. I think the recommendations by staff are fine. Is there any other comments?
Madam Chair, members of the board, item number 2 on the appraiser certification states that he inspected the property. Obviously, he didn't.
Right.
This is an ethical thing. I think the appraiser probably has done this before. We don't know that. But to the degree that there's remedial use cap, I would be in favor of that, as well as all of the other recommendations. It was a pretty big deal. Saying that you did something that you didn't do. That's, to me, that you boil it down in appraiser language, he's lying.
Would you want to exchange the 15-hour use PAP course for one of the other courses recommended, or add it?
Just add it.
It's the board's pleasure on that.
So I would take him up to over 40 hours of coursework. Is that right?
I believe it'd be about 39, but yeah.
And none of this would qualify for continuing education?
No, it would, because it would be a dismissal with education. This is the first go around.
Oh, okay.
So there's effectively, we're mandating that he take his continuing education?
You're pretty much choosing most of it for him.
Yeah.
And then, Marcia, if we were to go ahead and approve the staff recommendation with the addition of a use PAP class, may we also instruct the staff to relay our concern specifically regarding to the concerns that we've had about the appraiser not physically inspecting the property, but stating that in fact he did on the report.
So he's going to get a copy of this report, so I think that will make it clear to him.
Okay. Perfect. Thank you.
So can we get a motion on this?
Sure. I move for complaint 2021-1630 that we accept the staff recommendation of dismissal with coursework to include residential report writing for 15 hours, 7 hours or more, and comparative analysis and or supporting adjustments. The BOREA work file course, which I believe is 1 hour, and additionally, a 15-hour use PAP course.
Second.
Okay, we have a second. Let's take a vote. All those in favor of the recommendations, say aye.
Aye.
Aye. All those opposed? Okay, we completed complaint 2021-1630. The next complaint is 2021-1991.
So, board members, the investigator on this complaint is Scott Wentz again. In this complaint, in reviewing the respondent's report, several violations of USPAP state statutes and board rules appear to have been found. Some of the processes used to develop conclusions or interpret the data results reported in the appraisal report do not appear to have utilized recognized methods or techniques for their development. Additionally, the respondent's methodology for the adjustments in the sales comparison approach and cost approach aren't explained in a manner which the intended user or the client would understand. Some of the respondent's adjustments appear to have been very simply stated. Potential violations are 12-10-613-1B, violation of Part 6, 12-10-613-1G, failing to comply with USPAP, Board Rule 12.12, which is not having the copy watermark on the copy of the license, the record-keeping rule, and standards rules 1 and 2. The recommendation for this complaint is for a stipulation for diversion and coursework of 7 or more hours in residential report writing, 5 hours or more of data verification, and 7 hours or more of comparative analysis and or supporting adjustments. And Scott is here to answer any questions that you may have.
Well, knowing a little bit about this area, it is difficult, but they didn't seem to disclose the details about this kind of unique property. Pat, can you expand on any of that?
Yes. So just talking with the respondent and so forth, the respondent was claiming that it was basically a software glitch. Madam Chair, I'd actually contacted the software company, and they basically said that the problem was either a cloned report from the first place, or basically taking the report off another template. They claimed that the software company claimed that she'd worked for the software company for over 10 years, and she said that there had never been a glitch in the system, as the respondent was actually proclaiming. The actual property, it looks as though it was like a berm-like home. On the first page of the URAR and so forth, they'd stated that it was a ranch home and so forth. And basically from the actual sketch, you can see that it was clearly a unique property. And so I don't know if the respondent was just actually omitting things to actually get the subject through underwriting or not. Obviously, there were certain things that were incorrect as far as on the first page of the URAR, as far as the description of the actual subject property.
Yeah, that concerned me the most. And what was this for? What kind of, was this for financing or sale?
For the bank.
Yeah, it was for the bank.
In looking at this, and I'm familiar with this, I'm not familiar with that. I've been through the inside of this house, but anybody that's driven Glade Park probably has seen this house because it stands out, and it is a unique property. And I was really amazed at the short explanation and text addenda that he had there. And you had to look through the report to find where he talked about it being a berm home or earthship home. I mean, it just wasn't. It wasn't just put out there to make
that. And this was for a purchase also. So yeah, it almost seemed like there was some misleading information to make it. And I've done appraisals on straw bale homes and back when I did appraisal work, and those are difficult, but it doesn't mean you should not present the facts.
Right. Yeah, it's an extremely complex assignment, especially in this lending environment. But again, it doesn't preclude you doing the research and presenting it in a clear and meaningful way.
Yeah, I wasn't so upset about the adjustments. It's definitely difficult to make adjustments in that area and in that type of house, but I was more concerned with the disclosure of the information. Those are my comments on that one.
Yeah, it seems that the appraiser just did the actual disclosure in the actual addendum of the actual appraisal. So if you didn't read for the intended user, if they didn't read through the actual whole appraisal report, some of that information might not have been construed.
Right. And Scott, did I see that there were 5 prior complaints?
Yes.
Yes, that is correct.
Anyone have any other thoughts on this? Do we go with the recommendations? Or?
Should we also add use cap as an additional coursework?
Madam Chair, I would think that's appropriate. I think that should be required for any appraiser that comes before us. If there's an assumption that there's a violation of use path, they should revisit use path.
All right, I'll make a motion on 2021-1991 to accept the coursework as provided from the investigators, 7 hours or more in residential report writing, 5 hours in data verification, 7 hours or more in comparative analysis and/or supporting adjustments, plus the addition of a 15-hour use path course.
Second.
Second.
All right, we have a second. Should we take a vote? All those in favor of the recommendations plus the additional use path class, say aye.
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 All those opposed? That passes. Now we'll move on to complaint 2021-1867. Robert Walker is the investigator.
So the complainant alleged that the respondent used inappropriate comparable sales and unsupported adjustments. In reviewing the report in the work file, several potential use path violations were discovered. There appeared to be scope of work and record-keeping rules issues. The respondent also failed to fully analyze the neighborhood and the market area or to properly document the analysis used to select the comparable sales. There was little to no support for the adjustments made in the sales comparison approach. The cost approach was not developed because it was not required by the client, and there was no reasoning provided for the opinion of site value. Finally, there are insufficient summaries of analysis to support the opinions and conclusions made in the report. Potential violations identified are 12-10-6131B, violation of Part 6, 12-10-6131G, failed to comply with use path, Board Rule 12.12, not having the copy watermark on the license, the record-keeping rule, the scope of work rule, and standards rules 1 and 2. Recommendation is for a stipulation for diversion with coursework of 7 or more hours of comparative analysis and or supporting adjustments, 7 or more hours of residential report writing, and also the board's work file course. And Rob is here to answer any questions you may have.
Madam Chair, I'm curious about the watermark on the license. It seems I don't recall having that being brought to the board's attention before or incorporated into these findings. Is there significance to the watermark or the absence of it? Have appraisers been, have they been making up licenses like vaccination cards?
So I'm not aware of anybody making their own licenses. This has been a regulation that's been on the books for a long, long time, and it is a pretty common violation that they find in the investigations. It's definitely something that when we go through the board's rule review again, that we'll probably take a look at the significance of it.
I must have overlooked it or not not heard it or something in the past. Right? So I appreciate the clarification.
Well, this is another one of those difficult markets. I think you said something about you thought the use of the sales were, I guess, not appropriately communicated, or there weren't the correct sales, or can you talk on that a little bit? I don't think your microphone's on if you're speaking.
The main issue with the comparable sales was more that he was really unable to actually elaborate on how they were chosen. It seems as if he did give some criteria, but like half of the comparable sales used in the report weren't actually, within the criteria that he had stated. So that was probably the main concern. There being a small market with, an older small property is difficult. But he should have probably at least elaborated a little bit better on how they were chosen.
Didn't he say in his response that there were 4 sales available in this area? Something like that? He didn't have a lot to choose from?
Yeah, there were not. Then again, I basically said that the market area was all of Georgetown, which seems reasonable due to the size of the area. However, I looked in the previous, I think, 12 months, there were 31 sales. He could have at least, in 2 or 3 of those were not included in the report. So he went out of the market, he went, over 12 months old, that basic criteria that is generally used.
Yeah.
The site values stuff a lot of things. Seems like it's difficult we have this issue quite a bit on including the cost approach or not. Final reconciliation, though, was to the sales comparison approach. And I wouldn't have used income approach on this, would you?
I don't believe so.
Well, the cost approach on a 140-year-old structure is difficult.
Yeah, I believe all I mentioned in the site value was that there was basically no support or documentation for the value. It is certainly reasonable not to try to develop a cost approach on a 140-year-old house.
Yeah.
Any other comments on this? I think this was a difficult one. I mean, again, working in some of those kind of markets, it is difficult. The residential appraisers pushed into that.
So, Patrice, I have a question.
Hard to do. Go ahead.
Yeah, and this, I think, is less of Robert, more of the appraisers on the board here. I'm not a single-family appraiser, but I know when you've got a home and it's in an older neighborhood, there really aren't land sales. You don't have lot sales. Lot sales are hard to come up with, even if you're in a new neighborhood. Like, let's say in Denver and you're in Wash Park, you might be homes purchased and torn down. I don't know if that's the case in this neighborhood or not, but says, but I'm also thinking of practical application. Is it practical to assume, and I'm really focusing on the land value part of the cost approach, is it really practical to assume that the appraiser is, and are generally single-family appraisers when they take the assignment of an old home in an old neighborhood, thinking that they're going to need to gather land sales in order to support the lot value? I would say I would be surprised if that were typical, but maybe this is where use path diverts from practical application in the appraisal process.
Well, that's, I think, one of the issues is we are required, or we should be supporting the land value, even if that's the only component of the cost approach. But a lot of lenders, and you guys in the residential world today can speak more to that, but that is one of the problems. And we see a lot of people not understanding how to come up with that. But if it's a part of their scope of work, they should be finding something besides.
So should they get land residual if the homes are selling for $500,000? Typical home to lot ratio is 15 or 18%, and therefore, is that sufficient? But we've just heard this a number of times, and for anybody listening, and for me, I'm just curious. You have to use it.
Chris can talk about this a little more.
Well, as far as the stuff I reserve or review on the residential side, there are, it's probably the exception when I see land values on a home like this in an old neighborhood where there's no sales, and the ones that do use the extraction.
All right, thanks,
but
Chris.
Sometimes some lenders require it.
Very
right?
true. Yes.
Okay.
Some lenders will require it, but not many residential mortgage companies do I see where that comes back as a revision request on those reports.
Maybe a topic for future on how to handle these, since we do see it quite a bit. Any other comments? Anybody want to make a motion?
Madam Chair, make a motion to accept the staff findings for complaint 2021-1867 as presented.
Second.
Okay, we have a first and second. Let's take a vote. All those in favor say aye.
Aye.
Aye. All those opposed? Okay, motion passes. All right, we have licensing matters next, 2217.
So board members, this is an application for licensure as an AMC. We received it on December 29th of 2021. The proposed controlling appraiser has had her appraiser's license disciplined in the state of Ohio for practice violations stemming from 3 separate complaints that were filed in 2004 and 2006. She has completed the disciplinary terms associated with those cases. In 2020, the AMC stipulated to a settlement of citation because the controlling appraiser had not disclosed the prior license discipline that she had in Ohio. The AMC was required to pay a $5,000 fine. We are just bringing this to you so that you can make a licensing decision on whether to approve or not. And Rod Walker was the investigator, and he can answer any questions that you have.
So when this application was received, that's when the information on the 2004-2006 cases was not disclosed. Is that correct?
No, actually, I believe it was disclosed for our application. It was initially not disclosed in California when they were applying for an AMC license there.
In California, okay.
Yes.
I missed something there. And what year was that?
Let me take a look.
I think it was 2020.
Yeah, it was somewhat recently. So it would have been, I think, 15 years before, 10 to 15 years before were the Ohio issues before the California that she failed to disclose. They found out somehow.
And you spoke to this person, Rob?
I did not speak to her specifically, but I did follow up with both the state of Ohio as well as the state of California. There are no additional issues in either state.
Any AMC comments from you, Chris?
No. It looks like her issues with her license was, I think she states in the early part of her appraising career, and, it was a long time ago, and she looks like she's kept everything clean since then. There's not been issues other than this thing about not reporting to California, which, that's a concern, obviously, but I understand that, right? She disclosed it in her application to Colorado, correct?
Yes.
Yeah.
Okay. She's learning.
She's learning.
All we need to do is make a recommendation, correct? Whether we would approve, deny, or approve with restrictions.
Madam Chair. Madam Chair, can I ask, did she do anything wrong for the state of Colorado?
No, but the fact that she's got something prior is why we have brought it to you. You don't see these very often, so unlike some of the other issues that have come up with other background investigations, because these are kind of unique, we bring them to you for a decision.
Madam Chair, I'm okay with allowing this license to be granted.
That's a motion. I second it.
So you recommend for full approval with a positive opinion?
Yes.
Okay. And we have a motion and a second. Do we have a second? Was that you, Larry?
Second. Yeah.
Okay. So on the licensing matter 2021-2217, all those in favor of a full approval, say aye.
Aye.
Aye. All those opposed? All right, we will make that recommendation. Next up, go ahead.
Madam Chair, you don't have anything left on your agenda, but we did get the written comments from Joanna Postle.
Okay, right.
So if you want to resume your rulemaking hearing, I can read you her comments, and then you can make a decision about the rule.
Can I just resume the meeting or do
I think you can pick up where you left off at.
Okay, so I'm going to have to pull this back up again. So we have testimonies and we have a speaker regarding the rulemaking hearing 5.1.
Yeah, she's on the road currently, so she emailed us her comments after we had the technical issues. And what her comment says is, I just noticed the rule says credentialed, but it would still allow a licensed residential appraiser to supervise. If a person only wants a license and not a certified license, then I can gain experience under a licensed residential appraiser. If the rule stated certified, it would close that loophole. So those are her comments, but I wanted to make you aware that the state statute does allow a licensed appraiser to supervise, and that's 12-10-621-1A. So the statute would conflict with what Joanne was proposing as far as a loophole solution.
So we have no choice. As the statute indicates that we can't make that modification, correct?
You couldn't exclude a licensed appraiser from mentoring somebody else on experience as long as it was within the purview of that licensed credential.
Perfect.
Okay. All right, so now we've, and there's no other testimony for this rule, correct?
Not any that I'm aware of.
I'm sorry?
That is correct, Madam Chair.
So now we can make a motion.
Yes.
Can I get a motion concerning the adoption of proposed amendments to Rule 5.1?
Make a motion to approve as presented to the board.
Second.
Okay, it is moved and seconded that the proposed amendments to Rule 5.1 be adopted. Do we have take a vote on that? All those in favor say aye.
Aye.
Aye. All those opposed? The motion carries and the proposed amendments to Rule 5.1 are adopted. This concludes the rulemaking hearing. And I believe we don't have any expedited settlement program matters and no attorney general matters. Is that correct?
Correct.
Correct, Madam Chair.
So can we move to end this meeting of the BOREA on March 3rd, 2022?
Madam Chair, I do have one question. I don't know if it's appropriate to bring it up here at this time or maybe at the next meeting. We, over the past week, received 2 emails, one from the division director and one from our council that seemed to conflict or allow for different things. Is there been any direction or determination? Does the board, desire any conversation on future disciplinary actions with regard to that communication or those communications? I guess in a nutshell, do we quit finding appraisers or, because we have too much money, or do we, find alternative disciplinary measures? Or do we look at other things in the, do we have the, okay, I'll stop, but I have one other question.
So my email to you was regarding a budgetary issue that is short-lived and will conclude at the end of this fiscal year, which is June 30th. And I mean, frankly, the fines that you impose are not big revenue drivers for your licensing program. And if your sunset review goes through as planned, this will be a non-issue for your program because your fine revenue will start to go over to the general fund rather than back into the division's cash fund. So I just wanted to point out that you do have alternatives, and I think your board counsel also did that as well. There are alternatives to fining, and up until recently, you were heavy on education and not imposing fines. I just pointed out that we've got a budgetary issue that is short-lived for right now, and because we need to halt the income of revenue, that's why we were focusing primarily on education at this point. And I think depending on who is the recipient of the requirement to take the 15-hour use PAP, that may be more of a punishment than actually paying a fine.
I would agree. And probably more helpful.
Yeah.
My secondary concern would be, and if it's only short-lived, it kind of eliminates that, but continuing to discipline appraisers in a consistent manner. I always go back to licensing efficiently and disciplining fairly. I think those are probably the division's 2 overarching goals. And if we treat appraisers disparately, I don't think we're doing our job to the degree that we can administer consistent disciplinary actions. I think we should. And by eliminating the financial component, does that do that? It's not going to be long-lived, so it's probably not a big issue. But what a unique problem that government has.
Well, and I mean, when you ratchet up the education, they're still bearing that expense. The expense is just going somewhere else. It's going to a private educator rather than the Division of Real Estate's cash fund.
Well, when you ratchet up education, how much is the appraiser's time worth? And so I think that when you take education up and they've got to take an extra 15 hours, it may be well more than the fine that would have been imposed. So,
absolutely. Thank you, Madam Chair.
Thank you. Anything else? No nothing. Do we need to make a motion to adjourn?
Yes,
Madam Chair,
please.
make a motion to adjourn.
Okay,
Second.
and second that? Oh, thank you. All right. Meeting, do we need to vote? I don't think so. All right, meeting's adjourned. Thank you.
See you next time.
Thank you.
Thank you, board members.